said slow down, they said fall back, but the doubts hit the tank and it's all high octane gas. Let's go, yeah, we run it up clean. Funny thing about the hate is it fuels the machine. Let's go, all bark, no bite, no teeth, while they're stuck in the comments, we're 10 steps past believe. Eyes locked, no breaks, no pause. Every shot they take just reminds us who we are. We don't beg, we don't fold. If they're watching this mad, yeah, the plan's still gold. So talk it out, type it slow. Every hater in the crowd just helps the engine go. No fade out, no laying low. Fueled by the hate, still winning though, yeah. Yeah. Roll it back, run it up, save energy, let's go. Let's go.
Hey, everybody. Get your emotional pitchforks ready, a stiff drink, or some ice cold water, because we're doing another petty playback of the hearing from this morning. Because, well, why not? Um, hopefully, the judge is making some important decisions today. No spoilers here, but we will watch it on 1.5 speed because I cannot watch any of these lawyers talk at regular speed. Tyler Robinson, if you are unaware and have been living under a rock for the last 9 months, is the accused unaliver of Charlie Kirk. I am not going to get political here. However, I don't believe anybody should be unalived based on their political beliefs. And because of that, the certain unaliving penalty is at stake. And the defense wants it taken away, and that will be one of the things that the judge rules on today. So we are going to get into this right away. Joining me today is my friend Flash Fan. How are you doing today, my friend?
I'm good. Thanks for having me. Hey, everyone. This is the real Flash Man.
Yeah, I guess some drama happened this morning or something. Like, I don't know what's going on with you.
Yeah.
But as always,
also, I believe he's ruling, and that's the case they continue to hold it in continue. He's supposed to rule on the camera ban. They want to
oh my God, more cameras.
again for the preliminary hearing for the 14th time in a row.
But as always here, we deal in facts, not speculations. We're watching the actual hearing. We will interrupt our comments because that is what fair use is, and I am snarky. I am snarky. Flash Fan is the intellectual one here. I never claim to be smart. I'm the bitch of the operation. He's the nice one. We balance each other out. However, I believe these things need to be seen and people need to understand how our court system actually works because I've seen so much misinformation in this court case based on people thinking that things are supposed to happen in our court system that's not the way things work. And you will hear me scream at the court case or at the screen more than one time. This is not how that works. And I apologize in advance because Kathy Nestor and her band of merry Californians are not my favorite people at all.
You end up streaming it. You have to deal with her for a week. With this preliminary here.
Yeah, I gotta figure out a way to curb my attitude on that one. However, I have really no idea the facts behind that. I just saw a headline, so I have no idea. However, we are going to get into this because it is an hour and 33 minutes, and I will be on with Nick Starro for his Slightly Budged show Unfortunately, I will not be slightly buzzed because there's no alcohol in this house right now. However, I think after this, I'm gonna be extra snarky because this is just. As always, we have the judge acting as the judge, acting as the prosecutors here. We have Christopher Ballard, Jeff Gray, Chad Grunander, and right now we have Stacy Visser acting as the defense attorney. We will see if anybody else shows up.
This judge is nice. He needs to be a little bit more strict. I found this South African case, which surprisingly there's cameras in it, but the judge is strict. He's like, "Come on, we need to proceed."
And I like a strict judge. I'm a very by the book person, and I also don't like my time wasted. Which is kind of funny considering I waste y'all's time every day, but that's the point. Oh my goodness. Hey Janet, thanks for being a member for 11 months. Tentacle Nation. Hey. Oh, and by the way, you are almost at your 1-year anniversary. Yeah. And I can get a Walmart order before the show, just saying. Well, can you get a Walmart order for alcohol? Like that just seems weird. That just seems weird to me.
Go to a liquor store around the corner or something.
I mean,
or DC, they had liquor stores around every street.
We have a gas station down the street. Like I could go, Oh wait, no, there's 6 beers in the fridge. 5 beers in the fridge. My dad was here a couple weeks ago and bought a 6-pack, left them in my fridge because he didn't have a fridge at the time, and I still haven't brought them over to his house. That shows you how much I actually pay attention to what's in my fridge, because I didn't realize there was 4 or 5 Miller Lights in my.
Everybody do that at some point. I'm looking in the fridge. I'm like, oh, there's some ham hocks in here or something else.
Oh, I'm pretty sure there's a container for Mr. Squid's lunch that needs to be emptied that he filled up and never took and left it. And I'm like, that's his lunch container. He can empty it. If he filled it up, he can empty it.
My brother-in-law do that all the time. He's like, oh, oops, I forgot to take this with me.
I have no problem making his lunches and or doing the dishes that he creates with his lunches. However, I have a rule, and they're just a household rule. If you fill it up, you be the one that empties it.
Oh, you different in my house. If somebody fills a bowl of food up and it don't get eaten, somebody will eat it.
Well, that's the little. If she doesn't have food, we finish it. But if she starts food and doesn't eat it, we'll end up finishing it. But we are going to get started with this. Oh, there's our favorite Kathy Nestor.
They have internet issues too, so that's why I started the 46-minute mark, because that's when.
Of course they do. Why wouldn't they have internet issues?
Or audio issues. That's when they audio cuts in at the 46-minute mark.
So the bottom middle is Jeff Gray. That's the county attorney for Utah County. Utah County, Utah just seems redundant to me. Kathy Nestor, Corey Richens' defense attorney, which is what she is infamous for, which is what I know her from, and I can't stand her from. We've seen our fair share of annoying defendants, but Corey Richens just was another level of.
I think she just files her appeal notice or something or the other.
Oh, speaking of appeals, I have the appeal for what's her Mackenzie Shirilla. I have the appeal document.
Oh, her, yeah.
Her decision.
I still need to watch
Tyler James Robinson.
So tomorrow, I am doing a stream tomorrow around this time-ish. We are talking the response or the latest documents in the Hales case, since we're not doing that today. There's been some interesting ones. Then Monday, we are doing a lot of the Supreme Court decisions, and we might include Mackenzie Shirilla's appeal decision in there too.
Did Carly Gray stuff come back?
Huh?
Did Carly Gray stuff come back? That decision?
I don't know. I haven't seen anything the last time I looked it up, but I don't. I'm bad at research. The research thing is your area of expertise. If you all don't know Flash Fan, you really should. He is a research expert. I am like mediocre at best.
They trying to get me to start streaming. I might. They may have convinced me. I don't know yet, but I'm seriously considering it.
And Jeffrey, thanks for the member for 15 months. Pfft, the member's crawling. I don't know what that means. This member's crawling. Well, I do have a stream Sunday night about getting off the floor. So, on my other channel. Hey, Boosh, how are you? You didn't find any fentanyl in the home? It was all in Miss Rich's stomach, man.
God
Yeah,
dang.
just
I really regret not watching it well.
I couldn't watch that entire trial because Kathy Nestor and Corey Richins were just so insufferable to like even look at. Like, like the Corey Richins thinking that like the audacity to unalive somebody anyway, but then the audacity to unalive somebody and then write a children's book about grief and try to make money off of your crime. The fucking odd and take advantage of your children's grief about losing their father is just like, that's some Ruby Frankie level shit right there that I just can't get my ass past. And hey, Spawn Raiders, how are you guys? Oh, now you can fix her? Okay, you fix her. You let me know. You let me know how that goes for you, Boosh. I'm all here for it.
Kind of like who was it? I think it was it Baker or somebody that said they could fix Sarah Boone. I'm like, yeah, good.
No, that was Unhung Hero, but I think his wife would have a problem with that. Because when he said it, he wasn't married. Now he is. I think his wife would have a problem with that. Just a thought. I think Mrs. Unhung Hero would be, no, bitch. No. You know. All right. Anyway, we'll get started with this. I do have it on, okay, Jeffrey, now I get it. Sorry, the joke went over my head. 9 months is baby, then you learn to crawl. Come on, Squid, where's your imagination? You were streaming. 2, I would like to get through this entire stream or this entire hearing today. I'm just a thought. So we are going to do this entire hearing now. No, but if you would like a link, I can send you a link.
Impartial jury trial. To protect the fundamental constitutional rights of both defendant and the state, this court, sua sponte, issued a protection order pre-trial and trial publicity on September 16, 2025. The order explicitly stated that lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6
I think he's
of the Utah Rules of Professional Conduct.
No,
the order further incorporated Rule 3.6a's prohibition against making an extrajudicial statement that the lawyer knows or should reasonably know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
Okay, and also, like, here's the thing. If you're ever going to do an interview with somebody, you should expect that it's going to be disseminated. Just a FYI, if you ever do an interview with anybody, expect that interview to be disseminated in some shape or fashion. And if you give some incriminating shit in that interview or you fuck up in that interview, expect that interview to be disseminated even more.
I don't think he's going to find the prosecutors in contempt. So far, the defense has not been doing good in this case. I mean, every motion they have been denied so far.
Oh, Diana, I hope she is doing okay. Give her a hug for us. I sent you a link, Spawn, but that can't be easy. But I hope we can make her laugh or smile or something to get her through this hard time. So we'll see what he has to say. Kathy Nestor, we got to talk about angles. Like, I have kind of a double chin too, because I'm not the skinniest bitch in the world. But like, woman, girl, come on, lady. We got to talk about angles. When you have a double chin, looking up, is not the angle for you. You want, be it I'm not the most photogenic. However, speaking of photogenic, Spawn, how are you?
The fuck? In the fucking heart? The fuck?
What do you mean the fuck?
The 3 hours I had to put up with you yesterday, and you
Wait. I said I had to go like 5 or 6 times.
yes, but me and Papa Squid had conversation when you know when the kings talk, we need to talk. You know what I mean? I still blame Flash Fan. Flash Fan, I'm sorry, mate. It's your fault.
I wasn't there. I don't even know what it's about.
Anyway,
Right. So you want to get this done this month, do you?
kind of. It's only a
Oh, right.
it's only a 45 minute hearing, so we should be good. But
Yeah,
No,
this,
it's like
this is short for them.
yeah, for them this is short.
so. Is this now a different day because young
Yeah,
lady
this
is
was
pouting?
Yeah,
It's the same day.
This was
No.
today. This was
Yeah, this
Oh.
2 hours ago.
Yeah.
Oh, right. Okay. Well, young lady is pouting, so she must have had a good night last night. The lady in the middle, she probably had a good night last night because she's got a
She
little
never
bit
has a
of
good night.
makeup on. Say
She
what?
never has a good night. It's
Okay.
Kathy Nestor. I'm pretty sure she
Okay.
goes home and cries herself to sleep every night. I would if I were her.
Wouldn't surprise me. But yeah, hello everybody. If I'm not saying hello to you in chat, but I'm going to mute myself because apparently, you know, I dragged this shit out for months. Like, you know, talk about, I mean, like dragging out content. You know, hint, hint, nudge, nudge, wink, wink.
I
You know
got
what I mean?
other stuff to talk about. We got a whole bunch of Supreme Court decisions to talk
Oh,
about on Monday,
I'm
including some
going.
2A decisions, including some border decisions. You know,
I'm
So-
going on vacation. I'll be on the dark side of the fucking moon when it comes to that. Just saying.
Yeah.
Still blame Flash Fan. Anyway, hi Flash. How you doing, buddy?
Hey.
y'all crack me up.
I'm going to mute myself because I'm going to go and have some food.
What's that
No,
like?
actual fact, I'm not. I'm just going to mute myself because I've been
I had a spoonful of this before the stream started.
right. I need to say this. I have to say this. I'm sorry, but it's got to be said. Nutella, large tablespoon into a glass, a little bit of milk. Once you stir it up and it's completely stirred, you then add your beverage of your liking to it with ice.
Okay, I will try it.
I don't think I could eat neither.
I don't drink milk. But
Don't Nutella have peanuts in it?
hazelnuts.
Yeah, I'm allergic.
They do have a peanut version now, though.
Yes, they do. There was a white chocolate version as well.
Oh, okay.
Hey, Roy, hugs.
Hi, Roy. Good to see you. Right, I'm muting, so
Hey,
you can't blame me
Christine,
for
how are
taking
you?
too. Yeah, I'm muting, so you can't blame me for this taking too fucking long. It's not
Sounds
me who
good.
drops her phone.
Anyway,
Yes. Sorry. Yeah, I see it.
Matter.
I see that. I see
Following a
that.
motion by the
Got an
state
itch,
for
have you?
clarification regarding the term witness, the court issued an amended order on December 15th, 2025, clarifying the scope of the attorney's duties to instruct their respective teams. The present controversy emerged following a public filing by the defense on March 27th, 2026. Defendant filed a motion to
I love how he says following a public filing. He makes sure to include in his order that it's a public filing by the defense.
I can't wait for him to say respectfully denied. Like,
I think that's foreshadowing. I have a feeling that's foreshadowing. Oh, this is fighting words. Spawn, I'm glad you recognize that you screw up stream schedule and derail continue.
Get back in your box.
Stopwatch.
I'll be honest with you. I've got the biggest grin on my face. As soon as I saw that comment, I knew we were going to spend 2 minutes talking about that.
Oh, yes. Yep. Speaking of derailed.
Hey, I was quiet. I was muted, so don't blame me.
No, I was like, speaking of derailed,
Yeah.
You know, it's a thing. Yeah, I love the stopwatch. And love it. Love it. All right. Getting back into it.
vacate or continue the preliminary hearing. In that motion, defense counsel characterized a forensic summary report from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, by stating that the ATF was unable to identify the
Yes.
bullet recovered at the autopsy to the rifle allegedly tied.
You didn't know what ATF stood for?
I don't. Forensics and stuff like that goes over my head. So when it gets to the forensics part of the trial, like yeah.
Alcohol, tobacco, and firearms. And explosives.
Okay.
So,
To Mr. Robinson. The actual ATF report concluded that the bullet jacket fragment could not be identified or excluded as having been fired from Exhibit 1 rifle, and that the results of the comparison was inconclusive. The defendant's framing of the ATF report in an unsealed public court filing promptly generated substantial media coverage. On March 30th, 2026, the Daily Mail published an article with the headline, "Bullet used to kill Charlie Kirk did not match rifle allegedly used by suspect Tyler Robinson, new court filing claims." Other news outlets and social...
and we did cover that, and I went through that report on my channel.
I'm about to go back and watch because like I said, learning about
I read the article, and then we read the report, and then I believe there was a couple of bullet or ballistics experts that were on different podcasts, and I played snippets of what they had said. And I also showed bullets that are not the same size as the one used in this crime. However, they are the closest thing that I currently have in my arsenal, you could say. If you want to title it that. However, we did talk about that. And this is why I hate the media, because the defense knew what they were writing in their motion, and they knew how the media was going to spin it, and the media spun it exactly that way. Did not match. Inconclusive and does not match are not the same thing. And lawyers know that words matter. It's one of the reasons that good lawyers are good lawyers, but some lawyers can be sleazy lawyers because they use words to manipulate things. And I can do my fair share of manipulating, do not get me wrong. However, that's their entire job, is to manipulate and find things and find inconsistencies in things. And
I feel like that's what more you get a bad name, though, the good one anyway, because every time you always hear that, like, oh, defense lawyer, they're trying to manipulate juries. Like,
it kind of, in my opinion, like I said, not a lawyer, but I know some. That's it. It can easily go that way, where, like, going back to a certain situation of someone who might have had their license taken away by the state, by the Florida bar, was upset that people were phrasing things in a certain way. I didn't agree with her being mad about it because shit happens, but I understood the loophole that she was using and the technicality, because words matter. And how you phrase things matters. When you phrase things as in an article of does not match, people assume that you're telling the truth. But when it is phrased in the actual report as inconclusive, that's why I showed the intact bullets, because how we're talking fragments here. Like, we're not talking intact things, and even the intact ones are so small. I mean, they look really big in comparison to certain other things, but in the grand scheme of life, a bullet fragment has gone through a human, has hit bone, is degraded by metal, and remember, blood has got a certain pH to it. And remember our chemistry, that metal and certain materials do not mix well. So things will start to degrade based on the fact that they've went through human flesh. You gotta there's a lot that is missed by the media and a lot of nuance. And that's what I hate what the defense did is they put certain things in their motion knowing that the media would read it because they know people are reading it. That's one of the reasons they're so pissed about the motions being public is because the public reads everything.
Yeah, they have a right to, even those who can pay for it. I mean, everything can be found in the seal. I think only thing that they say should be found in the seal, like if it's important stuff like medical and stuff like that.
Yeah, which I can totally agree with.
Yeah.
Like we don't need to know we don't need to know every aspect of someone's like medical history. Like I get it.
That's what they were saying. The judge and the Derek Rosa, that teenager in Florida, took a plea deal. They said this judge was putting this medical stuff out there in open court. I'm like, come on, man.
But the defense was sleazy because they knew that it was going to be misinterpreted. And then people were going to make articles about it, and lots of uninformed people were going to read those articles and assume. And just like the defense is so concerned about Tyler Robinson getting a fair trial, well, the prosecution is entitled to a fair trial as well.
And the victims. The victim's family, even the defendant's family. I mean, with the defendant, but everybody's entitled to a fair trial. That's a party to the case.
Don't get ahead of us. We're not there yet. We haven't watched the whole thing. We're on one part first.
Media commentators rapidly echoed this narrative, characterizing the ATF report as exculpatory, a bombshell that exonerates Robinson, and evidence that the state's case possessed a fundamental problem. Faced with a rapidly expanding public narrative that falsely suggested that the ATF had affirmatively excluded the defendant's rifle as the murder weapon, Deputy Utah County Attorney Christopher Ballard engaged in several communications with media outlets, including TMZ, USA Today, PolitiFact, and Fox News, between March 31st and April 2nd, 2026. In these communications, Mr. Ballard sought to correct the record regarding the definition of an inconclusive ballistics test. However, during these interviews, Mr. Ballard also provided statements regarding the overall strength of the state's evidence, asserting that the prosecution had ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and that the state believed it would be able to overcome his presumption of innocence. On April 15, 2026, defendant filed the instant motion for an order to show cause for contempt of court, seeking to hold Utah County Attorney Jeffrey S. Gray and Deputy County Attorney Christopher Ballard in civil contempt. Defendant concurrently sought an order compelling discovery related to internal communications of the Utah County Attorney's Office, referred to as UCAO. The state filed its opposition on April 30th, 2026, arguing that Mr. Ballard's statements were protected under the safe harbor provision of URPC 3.6c, which permits a lawyer to make statements necessary to mitigate substantial undue prejudice generated by recent publicity not initiated by the lawyer. The state argued that the defense.
So, and that was one of my major points was everybody's always concerned about the defense not getting a fair trial and getting undue prejudice. We forget that the state is entitled to that same thing.
And the people they represent, the
victims' families.
Yep.
And also, that's why you've got that little statue with the weighing in one hand, and she's blindfolded, and then she's got, what is it? She's got a book in the other hand.
Scales of justice.
Yeah, and that's why she's blindfolded, so everyone is treated equally.
Yeah, but we always forget that the prosecution is entitled to that same right to a fair trial.
Yeah.
We always get so focused on the defendant, which in most cases is just and right that we focus more on the defendant than the prosecution. However,
Karen Reed in Massachusetts situation.
I've just seen a comment. Well, technically, TMZ is a paparazzi group.
Harvey Levin thinks of himself as a lawyer.
Who?
The guy who runs TMZ, or at least he used to run TMZ.
Well, I mean, at the Johnny Depp
himself a lawyer.
Yeah, I mean that guy who was on the Johnny Depp trial. I mean, he blew TMZ out of the water, didn't he?
TMZ was entertaining then.
Yes,
Morgan Tremaine, I think, was his name.
Yeah. 15 minutes of fame.
Yeah, and Harry, I don't disagree with you. However, there we go. I don't disagree with you. However, we have to remember that we do need to both sides are entitled to the same level of fairness. We generally only focus on one side because it's an individual versus the state resources. However, both sides are entitled to a fair and unprejudiced trial.
Yep, and your comment is correct. Courts aren't equal. That doesn't make it right.
Yeah, that doesn't make it right.
And
So
the other one,
the defense has always been worried about Tyler Robinson's not getting a fair trial, but they put shit out in the media where they put feelers out there. They drop little crumbs for the media to pick up and write stories about that can have a prejudicial effect on the prosecution. And once again, I find myself being absolutely like detesting defense lawyers. And I hate that. I'm like upset with myself that I'm like siding with the state on a lot of these things.
Yeah, I faced that dilemma in this trial too. I said defense attorneys were always my favorite. I always tell people all the time, my favorite attorney is Johnny Cochran and Thurgood Marshall. But lawyers like them are giving them a bad name.
And the more I'm seeing the current defense attorneys that are in the media and in the streamed trials, and this is criminal defense attorneys, not civil litigation.
Yeah, because we don't get to see a lot of that.
I'm like, is this the best they got? Is this the best this country has? We have 360 million people. We have thousands and thousands of lawyers. Is this the best we can come up with?
Well, I've got a suggestion. I've got a suggestion. Is basically take a page out of Mega City Judge Dredd. Just fucking train people up, like especially veterans. All right, dress us up, give us weapons that have got multiple different systems, and then we go out and we do the business.
You do
the business in the business.
No.
I knew you'd say that. 5 years hard labor.
To my YouTube FBI and CIA overlords who may be watching, that is in Minecraft. He is not serious. Do not demonetize my channel because of the thoughts and opinions expressed by a guest.
Yes, and basically, yes, and basically, Mega City and Judge Dredd are actually fictional characters from a cartoon called 2000 AD. So, and I am very, very full of sarcasm and satire. So, jog on.
Getting back to the hearing.
Yes, exactly. You're the one who derailed there, not me. Got witnesses.
And its misleading public filing necessitated the response. Defendant filed a reply on May 7th, 2026. On June 1st, 2026, this court issued a ruling and order granting the motion for an order to show cause, determining that the defendant had made a sufficient preliminary showing under Utah Code 78B-6-301 sub 5 to warrant an evidentiary hearing. The court concurrently denied the defendant's request to compel discovery of the UCAO's internal communications. The court held an evidentiary show cause hearing on June 12, 2026. During the hearing, the court took testimony from Mr. Ballard and Mr. Gray, both who were subjected to direct and cross-examination. Following the hearing, the state filed an unsolicited objection to defendant's request to remove the death penalty as a sanction, to which the defendant filed a response on June 18, 2026. Having considered the pleadings, the exhibits, and sworn testimony presented at the June 12, 2026 hearing, the court makes the following findings of fact by clear and convincing evidence. On September 16, 2025, this court issued a valid lawful protection order pre-trial and trial publicity. The order explicitly required all participating lawyers to abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct and prohibited extrajudicial statements possessing a substantial likelihood of materially prejudicing the adjudicative proceedings. The order was subsequently clarified on December 15, 2025. Deputy County Attorney Christopher Ballard had actual notice of the publicity order. Mr. Ballard personally signed the state's November 6, 2025 motion to amend or clarify the court's pretrial and trial publicity order. During his testimony on June 12, 2026, Mr. Ballard acknowledged his familiarity with the order and his ethical obligations under URPC 3.6. At all times relevant to this inquiry, Mr. Ballard possessed unhindered ability to comply with a publicity order. There were no physical or legal impediments that prevented him from adhering to the court's directives. On March 27, 2026, defense counsel filed a motion to continue, containing the assertion that the ATF was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. The actual ATF report concluded that the bullet jacket fragment could not be identified or excluded as having been fired from the subject rifle, rendering the result inconclusive. Relying upon the defense's filing, media outlets generated highly sensationalized and factually inaccurate headlines. The Daily Mail declared the bullet did not match the rifle. Commentators described the ATF report as a bombshell that exonerated the defendant. Between March 31st and April 2nd, Mr. Ballard engaged in extrajudicial communications with multiple media entities. On March 31st, 2026, Mr. Ballard was quoted by TMZ stating, "Generally, when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. There's just not enough there to determine whether the bullet was fired by a particular firearm. We have ample evidence to demonstrate."
And that's accurate, like inconclusive. You would think that the common person has the intelligence. This is the problem. Common sense. Sorry, I'm cursing. However, you would assume, there's where I went wrong, that the common person has the intelligence to understand that inconclusive means you can't draw a conclusion either way, because that's the frickin' definition of inconclusive. Inability to draw a conclusive decision.
Quick question of interest.
The floor is yours.
Thank you. Two things. At what speed have you got this video at the moment?
1.5.
Okay, right.
This is why we watch this shit on replay and we're petty about it. Could you imagine listening to this crap at real time?
No, absolutely
exactly.
not. Right. I mean, there's a reason why I'm asking. Top left young lady there.
Stacey Visser.
Yeah. Now, there's one thing I know, and it's very hard for people to actually, no matter how good you are, you will always get caught out looking at a different screen when you're supposed to be paying attention to something else. Now, for the last 3-4 minutes, I've been watching her. Her eyeballs are all over the fucking place. The face expressions, like she's wiped her face, her nose twice in a very weird way. Now, either she's got 3 fucking screens or one big screen and one screen on either side, and she's like going through paperwork or whatever. But I tell you one thing, just watch her. Everyone else is listening and they're looking directly. Oh, okay. The old guy looks like a cutaway of James Bond. He, wannabe, sorry. But she is all over the freaking shop. And look at her face expressions as well. Like she's either doing Amazon shopping because at one point.
I mean, it is Prime Day.
Say again? It
is Prime Day.
Oh, right. Oh, good point, actually. I need to check. Anyway, thanks very much for the reminder. Cheers, boss. Anyway, but the thing is, if you watch her carefully, you can see her arms moving. So she is typing. She is moving the mouse about, but she's doing very small movements. But
I'm wondering if she's typing and taking notes on a separate screen, but she can't type and look at the judge at the same time.
But yeah, you can tell like, it's, I mean, I can look at you and I can do 3 things because I've got the screens in such a way that I can see all 3 screens. Well, I've got 4, but I can see them all in one look. Oh, shit.
I have 2, but like here is one. And then my camera is on this one. And I actually have to scoot my camera over.
Yeah, but I've got...
Sorry, sound Scottish for a second.
Yeah. I mean, I've got them 2 there right in front of me. I've got that one there, and I've got that one over there.
You that one there. Like we can't see any of this stuff. So.
Oh no, you're not going to see it. But I'm just saying that, like, basically, if you look like in a cockpit, you've got a window to the left, you've got a window to your front, and then you've got a second window to your 1 o'clock, and then you've got a window to your right. Well, I've got screen in front, screen above that, so that means I've got a window. And then I've got my window to my left, and then I've got the co-pilot's window. So that's the way I've got it set up. But does that make sense? She But then again, if it's Prime Day, yeah, I need to. We need to hurry this shit up. Come on,
I
let's
mean,
get
you
on.
did mention that it was that maybe she was shopping on Amazon, so I'm like, it is Prime Day. I
Yeah.
mean, just a thought.
Yeah. I'm gonna go silent because I'm gonna go
You
and
gotta
check
shop
Amazon.
now. Okay. I love it.
Fucking right, I am. I'm gonna get the cat and the dog something.
Demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and we will present all that evidence at trial. Mr. Ballard further stated he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence. On March 31st and April 2nd, 2026, Mr. Ballard provided statements to USA Today and Politica Facts, strictly limiting his commentary to the mechanical and forensic definition of an inconclusive ballistics test, noting that ethical rules prohibit him from speaking publicly about forensic testing and the test results, but clarifying that inconclusive means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm. Having observed the demeanor and testimony of Mr. Ballard during the evidentiary hearing, the court finds that Mr. Ballard testified credibly regarding his subjective intent. The court finds that Mr. Ballard did not engage with the media out of a malicious desire to flout this court's authority or to intentionally taint the jury pool. Mr. Ballard testified that he believed his statements were necessary to respond to public reporting concerning the ATF report.
Watch her arms. Look at her arms.
In Utah, contempt proceedings are governed simultaneously by common law principles and the statutory framework outlined in Utah Code 78B-6-301. Section 78B-6-301 sub.
Oh, they're definitely texting each other. I guarantee you, she has a Mac, and they have iPhones, and she is texting this guy on the top right. And because every time her arms move and she looks at a different screen, he looks down.
She
Like
probably
his-
like, can you believe this? Not ruining our favor. We should file another appeal.
I just can't with these people.
And probably
sometimes.
some other colorful language.
Yeah,
No,
everyone
I
looks
think
at stuff
what they should
sometimes.
do. I think what they should do when they do shit like this, you have to stand in a full body, stand in front of a camera, and just sort of like stand at your desk or on a stool or something.
In a courtroom, you had to do that, but
And hey, Valor, it's just weird. It's weird. Like, yeah, ETM is at 407. If y'all haven't subbed over there, why not? We're talking about getting up off the floor, and when's the last time you did it on Sunday night? And I've already got that stream set up because that channel is, I hope, going.
5 expressly dictates that disobedience of any lawful judgment, order, or process of the court constitutes a contempt of the authority of the court. To hold a party in civil contempt for violating a court order, the moving party must prove 3 common law elements by clear and convincing evidence. 1, the person cited for contempt knew what was required by the order. 2, the person had the ability to comply with the order. And 3, the person intentionally failed or refused to do so. Utah law requires proof by clear and convincing evidence that the alleged contemptor knew of the order, possessed the ability to comply, and intentionally committed the acts constituting the violation. Von Hake remains controlling Utah precedent. Because the court concludes those elements are satisfied under existing Utah law, it is unnecessary to determine whether the objective good faith standard discussed in Taggart v. Lorenzen would independently alter Utah civil contempt jurisprudence. Even assuming Taggart provides persuasive guidance, the result would be the same because the challenge statements exceeded the objective limitations contained in Rule 3.6c. Contempt is categorized as either direct or indirect based on where the conduct occurred. Direct contempt occurs in the immediate presence of the court and may be punished similarly. Utah Code 78B-6-302 sub 1. Indirect or constructive contempt occurs outside the presence of the court and triggers robust due process protections. Because Mr. Ballard's extrajudicial statements occurred outside the immediate view and the presence of the court, this constitutes an allegation of indirect contempt. Due process for indirect civil contempt requires notice, an opportunity to be heard, and presentation of the charges via an affidavit or sworn statement detailing the facts constituting the contempt. The court must issue an order to show cause and hold an evidentiary hearing where the accused may present and answer and examine witnesses. Here, the court finds that all procedural due process requirements have been satisfied. Defendant submitted an affidavit of counsel. The court issued an order to show cause, and the court convened a full evidentiary hearing on June 12, 2026, at which the accused testified in presented argument. A critical distinction must be drawn between civil and criminal contempt, as the classification dictates the available sanctions. As the Utah Supreme Court articulated in Von Haake, the distinguishing factor is whether the sanction is conditional or fixed. A contempt order is criminal if the punishment is fixed, unconditional, and purely punitive, designed to vindicate the authority of the court. Conversely, a contempt order is civil if the sanction is remedial, designed to either compensate the aggrieved party for injuries resulting from the noncompliance or to coerce further compliance through a conditional penalty. Because the defendant brought this motion seeking remedial sanctions to cure alleged prejudice to his fair trial rights, the court evaluates this strictly as a civil.
You would think, and this is my problem with this judge and just judges in general, that read their orders word for word. Why do we need a hearing for you to read your orders word for word? Comment on your order. Comment anything else you have to say about your order, and then post your order in the docket. You don't need to read your order word for word. Am I the only person that has a problem with this?
Well, luckily his surname is not Luthman. Sorry.
I will be reading those documents tomorrow because we aren't doing it today because this hearing. However, I like this judge. He seems like a good person and wants to do the best job possible. However, if you wrote this order and you are putting this order into the docket for everybody to have access to anyway, why the hell do you need to read it word for word? Comment on it. Anything else that you would like to add to it and put on the record that you didn't actually write in the order. It's like people that make a PowerPoint and then read directly from the PowerPoint without getting any extra like context. It just defeats the freaking point. Like, am I the only person that has a problem with this? Is this just me being like a picky bitch, or is this actually an issue?
No, there's some judges that rules just a motion denied without or granted.
But and also Squid and Flashback, I mean, you may agree with me, you may disagree. I mean, that's one thing that I love about us is we can agree to disagree and not fall out or be whiny. Every judge, listen, just like you and AC1, excuse me, at the end of the day, he is a judge. He's got himself in that position because he's done his job. At the end of every judge is going to be different. You may like him, you may dislike him. You don't like the way they deal with the stuff, and you're going to get that. It's like the weather change. If he's doing his due diligence and another judge doesn't, and another judge that goes over top with due diligence, and the other judge just sits there scratching his nuts, every judge is different. So the way I see it, he is going through everything with a toothbrush to make sure that his T's are crossed. Oh, fuck it. You know what I mean?
I get that. But true. Okay. Thank you, April. I appreciate you. I'm being told reading it because he knows it will be appealed. Transcripts go to appellate court. But don't the actual orders go to the appellate court too? So like don't the actual documents that are appealed go to the... So if this order is appealed, the order itself would also go? The redundancy is like weird to me. But like I said, I'm medical. We only got so much time to get shit done, and having to repeat myself, that's my biggest pet peeve, is having to repeat myself. Like even to my family member, like not a YouTube thing, like an in general thing. If I have to repeat the same thing twice, I'm annoyed. So I can't imagine being a judge and literally reading what I just wrote. It was like, if you want to know what I said, just read it. It's like people in college. I remember this specifically. The professors would hand out the syllabus for the year, and they would ask the professor questions about the class when it was written right in front of you. And it was like, why don't you read and ask questions that are important and not waste everybody's time by asking questions that are literally on a piece of paper in front of you already? I hate wasting time.
He does talk for a very long time.
I hate.
Long time.
I hate. And if you come to my channel with any of this crap, you're getting blocked.
Come on, man.
yeah. If you come to my channel with any of that shit, you're getting blocked. I don't care who you are. You could be my best friend. I don't give a shit. Stop spamming my chat. So he should read it in different funny voices. Yeah. And Valor, thanks for being a member for 10 months. She still hasn't booted me. Every once in a while, I'm like, should I? Should not. I'm kidding. Depends. All motions and orders, however, higher courts rely on transcripts. Good to know. I thought they got both, and it was like, what's the point of reading it if they just get the documents too? But that makes sense. Now it begs the question, why does he have to write such long orders? You know, there are some judges who write, like that judge, the federal judge in the Eastern District of Wisconsin who wrote the order in the backdoor judge case. Edelman, he wrote a 29-page decision and order. 29 pages. Whereas I literally could have said that same stuff in probably 10 pages, but concise. Yeah, I don't have time to do what I need to do on a daily basis. I don't research as much as I want to for some things. I don't have time to get as much stuff done as I want around the house, in life, in 3D world. I don't have enough time for my friends in the 3D world.
What?
I don't have enough time for stupid shit. You know? So with that, we are going to get back into it. But this is why I always say that I am not a lawyer. I do not have a legal education. I don't claim to know these things. This is why I ask questions and we discuss it in chat, because these are questions that I would like to think I know a little bit more about our legal system than a lot of people because I trial watch. But these are still like questions that are like, they make sense to me, but they don't make sense to me. But my background is in medical. We do things straight to the point. Said patient did this with this many times for this reason. No response. Good response. Bad response. You know, like vital stable. Like we straight to the point. There's not a lot of, you know, pushing Squid's pissed off button is never a good idea. Yeah. I understand lots of cold shoulders from you. I don't know what happened yesterday. No, I don't care. No, Squid grow another tentacle? Yeah. If I could, I would.
Contempt proceeding. This court's publicity order expressly incorporated Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 reflects the constitutional accommodations recognized in Gentile versus State Bar of Nevada, under which an attorney participating in pending litigation may be subject to narrowly tailored speech restrictions when necessary to protect the integrity of an adjudicated proceeding. This rule therefore protects both the attorney's First Amendment interests and the criminal defendant's Sixth Amendment right to trial before an impartial jury. Neither constitutional interest is absolute. Each must be reconciled through a careful application of the rule's objective standards. Rule 3.6a sets forth a general prohibition. A lawyer shall not make an extrajudicial statement that they know or reasonably should know will be disseminated publicly and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Comment to Rule 3.6 explicitly enumerates subjects that are more likely than not to have a material prejudicial effect, particularly in a criminal proceeding. These prohibited subjects include the performance or results of any examination or test or the nature of physical evidence, any opinion as to the guilt or innocence of a defendant, the fact that the defendant has been charged, unless accompanied by a statement explaining that the charge is merely an accusation and the defendant is presumed innocent. However, the rule contains critical exceptions. Rule 3.6b permits a lawyer to state information contained in a public record without elaboration. Furthermore, Rule 3.6c provides a safe harbor or right of a reply. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Crucially, any response under 3.6c shall be limited to such information as is necessary to mitigate the recent adverse publicity. The Utah Supreme Court recently addressed the ethical boundaries of prosecutorial speech in a capital case in the matter of the discipline of David O. Levitt. In Leavitt, a county attorney held a press conference announcing his decision to seek the death penalty and stated that the state's key witness was credible based on a lot of evidence that the jury will never hear, and that he possessed evidence strengthening his belief that the defendant committed the murders. The Utah Supreme Court held that a prosecutor's opinion of guilt is particularly likely to create prejudice, given that his or her words carry the authority of the government and are especially persuasive in the public's eye. The court disciplined the prosecutor, recognizing while transparency is a legitimate objective, prosecutors possess a heightened ethical duty to ensure that justice is done, which includes respecting the constitutional rights of the accused, like the presumption of innocence. Civil contempt is an extraordinary remedy. Because contempt implicates both judicial authority and competing constitutional interests, the court defines its decision to narrow conduct presented by this record. This court possesses the inherent authority to regulate the conduct of attorneys appearing before it, and the statutory authority to punish disobedience of its lawful order under Utah Code 78B-6-301. As noted by the Utah Supreme Court, courts must maintain and protect the integrity and dignity of the profession. A judge presiding over a high-profile capital case bears an affirmative constitutional duty under the 6th and 14th Amendments to take preventative measures against prejudicial pretrial publicity that could taint the jury pool. The enforcement of the September 16, 2025 publicity order is squarely within this court's jurisdiction and within the court's inherent and statutory authority. To hold a party in contempt, the order violated must be clear and unambiguous. The court finds that the publicity order was exceptionally clear. It did not rely on vague prohibitions. Instead, it explicitly incorporated the exact text and framework of Rule 3.6 of the Utah Rules of Professional Conduct. It directed the attorneys to abide strictly by its parameters. The incorporation of standard, universally understood rules of professional ethics renders this order unambiguous. The court finds that Deputy County Attorney Ballard had actual notice and knowledge of the order. The record reflects that Mr. Ballard signed a motion seeking to clarify the order in November 2025. He never contested his awareness of the order or his obligations under Rule 3.6.
I don't know about y'all, but that don't sound good.
Nope. I've got one question though.
Yeah.
How much do these fuckers get paid to sit there and make facial expressions and play with themselves or with their mobile phones?
A minimum of $450 an hour.
Oh shit! I would be throwing the judge shitloads of paperwork. Oh, can you read that out as well, please?
I know it's one of the things where I'm like, that's one of the other reasons where I'm like, we can't make this any faster. It's interesting in a way, but the human behavior part of it and the psychology of it is interesting in its own way to me.
Oh yeah. Memo to self: check out night classes for lawyer training and bar. Sorry, did I say that out loud?
There's two places that rents on like this. Utah rents on like this. Well, no, there's more Idaho, Colorado, and also Africa.
Yeah, Flashman's covering a case out of Africa. That's a new one for me.
I mean, can you imagine, like, say for argument's sake, you, Flashfan, and me, we all decide to jump online and go to a legal school. Yes, we want to become lawyers. Okay, what do you want to be a lawyer in? Oh, criminal shit. Squid can go into physical and, fucking
medical
whatever.
Fraud.
Yeah. Flashfan can be fucking Judge Dredd. Whatever he wants to do, right? Do you know that if you go night classes or online, regardless of what course you do, except unless they go through government systems, 99% of the time it's an open book test. In the army, in the military, we have open book tests. However, they beast us to shit.
You had open book. What? That explains the army so freaking much.
Really? Want to go there right now? I'm game. I am game, Navy girl.
We had reading exams to get promotions, and they weren't open books. So
it's like, let's have a suntan on a fucking 60 million ton fucking flat surface called an aircraft carrier.
In Squid's defense, she could come back with Army vet did just get found guilty of underclassing in Alaska.
Well, the thing is, Flashfan, unfortunately, the Army do need a taxi, and that's what the Navy is there for.
No, the Marines need a taxi.
Oh no! I'm talking. No, sometimes, like the Navy, like pick us up and drop us off on the coast. And
not this Navy.
That's row the boat gently down the stream. Hippity hippity. Anyway, sorry, no. This from
the man that plays World of Warships on his YouTube channel.
Fuck off. I told you not to talk about that, short ass. No, I mean, seriously, like, I think everyone
You
in
wanna
this
play,
channel.
we play.
What?
I said, you want to play, we play, but we play
Oh
dirty.
yeah, let's play. Hey, let's get on the game right now. I'll fucking,
Let's
yeah,
get ready to rumble.
yeah. Yeah.
And Stacey, thanks for being a member for 6 months. Love your coverage and discussions. And that's
Yeah.
the thing. I never claimed to be a legal scholar. I just like to watch and, like, as a jury member, ask questions.
Yeah, but fucking hell, if they're sitting on their asses listening to him waffle on, and they're earning like 400, 500 bucks an hour, I want to. Hello, any educators, professors in law out there? I am willing to become a fucking bitch if I have to.
This defense team getting paid way more than $400. This is a high profile defense team, and they've been paid for by the state. I'm like, really? I wouldn't. If I'm the state, like, no.
Polymopicus thinks
Oh, polymop, right in the fucking. All right, yeah, blame me. Why not?
Time to wash the senior chief's coffee mug and blame Spawn.
Yeah.
I did consider becoming or going to school or trying to become a paralegal, just so that one, I could have more like credibility, but two, I could have more knowledge because I like to learn.
Can you imagine it?
I wanted to be a defense attorney, but I don't know. I've seen all these attorneys that.
Well, I look at it this way. Showing up and assuming that you're the smartest person in the room is never a good idea. I'm the smartest person in this room because I'm literally the only person in the room.
Well,
However,
I mean, look at her top left. I mean, she's pounding her lips so bad. She's basically going, "Those shoes, shall I buy them or not?" You know, I mean, seriously.
it's one of those situations that if you're not willing to learn, then I don't think you're a good person if you're not willing to learn. If you're not willing to ask questions, I can't say there are no stupid questions because I've seen them and I've pointed some out. You know, like when you're reading the syllabus and you ask it's like asking the professor, what day is this class, when the first thing is Tuesday, Thursday, 11 to 2
Yeah.
or 11 to 1. Like, you know what time this class is. Why did you ask?
Yeah, but aren't there hours? I mean, no, I don't know. I've never asked a lawyer, but are the hours of a lawyer where they can bill their client or the courts for time served? Is it really strictly policed, or is it just, oh, there's my fucking invoice?
I would assume it depends on the lawyer and the lawyer's ethics.
Yeah.
Well, I mean, from what we've seen over the last 2 years,
Or you have like they have in Florida with public defenders. They got to go to it. We saw it with Sarah Boone and that had to go to the administrator. And they were cheap. They didn't pay for nothing.
I think she's playing Candy Crush and getting paid. Probably.
Can you imagine?
Yeah, paralegals are research gods. They can make or break cases.
Oh yeah.
Can you imagine, like, suddenly there's a camera behind her, and then you can see, like, on the left screen she's got fucking Amazon, on the right screen she's actually talking in fucking.
Like I know a lawyer that got paid $1,300 an hour to send emails.
Get the fuck what?
I know a company that had to hire outside counsel for fear of conflict of interest with their in-house counsel. They had to hire an outside counsel, and that outside counsel charged the company $1,300 an hour, and all that person did was send emails back and forth to another attorney.
Right, I'm going to be contacting my boss tomorrow.
Like I said, I chose the wrong damn profession.
I mean, I'm not saying I don't. Yeah, I'm going to phone. I'm going to talk. Actually, I'll talk to him tonight.
They literally were a liaison between the company and the person's lawyer, because the person filed a suit, and the person's attorney was thinking about filing an EEOC complaint. And
that's insane. The money's insane. I think
because of that, they felt the need to hire outside counsel, which I wish they wouldn't have, but that's a whole different sidebar itself.
So you're telling me these 5 here, okay, are sitting there right now, and they've probably sat there now, what, for 2-3 hours?
Well, the bottom two don't get paid by
Okay, just the top
Bottom
three then.
two are state employees.
Right.
Yeah.
So the top three, they're sitting there. They've been there what? Let's say 2 hours.
It'll be an hour and a half.
Right. They're all in their own fucking homes, so they're not in the office. Right. So they're probably doing whatever. I mean, he seems so busy. He's not even paying attention to what's fucking going on the cam, and they're getting paid nearly $500 a fucking hour.
They're probably taking notes.
I guess
And
they-
remember,
I would
just,
get a green screen behind me and fucking lay down and have the green screen look like an office.
I'm not a cat.
lawyer
Remember
cat.
that lawyer? I'm not a cat.
Lawyer cat. Yeah.
Polymorphicus. Unfortunately, no. I do apologize, but unfortunately, no. I like to. No, sorry. I do apologize, fella.
And SMN, thanks for sending the 30 joules. Appreciate it.
What? Yeah, I need to talk
I
to you
don't know
about
what those are, but
I can say I always see people sending stuff all the time. Like, what does that even
Yeah,
mean?
what is that?
I don't know. But I appreciate it.
I have to do some research.
Hyping the channel, hitting the like button, sharing it out, especially streams like this that aren't the high drama streams. Aren't the Simeon-
He likes you more then. Well, obviously SMN likes you more than he likes me. So okay, I know how it is then. Just like me, I'm a fucking stepchild between fucking My Pretty and Squid Pro Quo. I mean, get in that basement, she says. You're gonna have fun, she said. Fucking sitting in the basement doing
Shush, there are people who actually believe that crazy crap.
do you know what?
There will be people in comments like, she's mean, she's horrible.
Yeah, and just for the record, Flash fans down here with me as well. And you should smell his feet after a hard day's work. Fucking hell. Chemical warfare, Jesus, eat your heart out. Oh shit, I've been moved to the top.
Hey, somebody thought I was a co-host now. It turned out
Someone wants to be in a sandwich.
Scammer.
Wait, what?
Turned out they were a scammer, but they thought I was her co-host.
Hey, you.
Speaking of co-hosts.
Uh-oh. Yeah, I just don't understand why half of this stuff is being discussed like this, where they could, this is probably why when it comes to big cases like this, they do everything publicly, and this is the exact reason why these cases go to bubble mash.
Hey, Living Life, thanks for the $2 super chat. Need to collab, Squid, Flash.
Oh, snap. Oh, snap. Oh, in the heart. Love you, Sharon.
Faces spawn, they're easier to look at.
Was that a soundboard?
Oh, so you want a response then, all right? Well, here's a response to that then. Here's a response. Right, this is probably the first time I'm ever going to do this.
No, there's nothing in there,
First
baby.
time I'm ever going to do this. One second. Right. Is that it? There you go.
Oh, no.
Wait 1 second.
Okay. Jules info. Virtual items you can purchase to redeem gifts. Hype from the YouTube mobile app are available to purchase in the YouTube mobile apps. May receive bonus jewels through special promos. Interesting.
Okay, so that's
Hey,
something.
man, how are you?
I
Happy-
just seen
Why the fuck is my
Happy
camera not showing up?
Yeah, speaking of co-hosts, mine has arrived, which means that the boys or men are on the couch sleeping. I guarantee you they both passed out.
that sounds like me on a Friday evening.
Did Daddy fall asleep? Did Grandpa fall asleep?
Beth got you eat some lunch.
Did Daddy fall asleep?
Yeah.
Okay. Are you awake?
Yeah.
Beth got you get some lunch or dinner. You get the itis, get in front of the television, and fall asleep.
All right, we're gonna get this started again.
During the evidentiary hearing, the first element of civil contempt, knowledge of the order, is established beyond doubt. Defendant alleged Mr. Ballard's statements to the press between March 31st and April 2nd constitute multiple distinct violations of the publicity order. The court analyzes these statements by categorizing them in two distinct thematic areas. First, statements clarifying the ATF ballistics report, and second, statements regarding the overall strength of the state's case and presumption of innocence. Allegation 1, statements clarifying the ATF ballistics report. The conduct. Mr. Ballard sent written emails to PoliticoFact and gave statements to USA Today and TMZ explaining the meaning of an inconclusive ballistics test. Specifically, he stated when the results of a bullet fragment analysis come back as inconclusive, that does not mean that the rifle did not fire the bullet. There just aren't enough marks on the fragment to make a conclusive conclusion one way or the other. Supporting evidence, quotes published in USA Today, PoliticaFact, and TMZ.
Hello.
Contrary evidence and defenses. The state argues
That's
these
my
statements were
response
expressly
right
permitted by
there.
Rule 3.6c as necessary to protect the state from...
Wait.
Right there.
So Spawn is not a bot, just in case anybody cares. You see Spawn's hand?
Yeah.
Yeah.
Hi, sweetie. Hi, baby. Hiya.
Look at all them wrinkles.
Oh wow.
Yeah. It's his hand.
Hi.
Hey, Ronnie, how are you?
Hiya.
Hey,
Hiya. Hello, baby sweet.
Okay. He's had a camera. He just doesn't show his face. No. We're not showing Nana's text messages on there. Mom, expect an incoming text message from your granddaughter. She sees it on the screen, and she gets all crazy. See, look, who's that?
Hello, sweetie.
Text.
Nana text.
Nana texted she.
Okay.
Man, I miss my grandma. My
Nana doesn't,
grandma
understand, Nana doesn't understand Russian, boo. Okay.
substantial undue prejudicial effect of recent publicity that the prosecution did not initiate. The defense initiated the media frenzy by stating in a public filing that the ATF was unable to identify the bullet to the rifle. The media twisted this phrase to mean the bullet did not match. Factual and credibility findings. The court finds that the defense's characterization in its March 27th motion to continue was technically accurate, but highly prone to misinterpretation. By framing the results as unable to identify, the defense neglected to include the ATF's concurrent finding that the bullet also could not be excluded.
See, oh, right there. That I like that, Judge. Yeah, they said that it couldn't be, that it wasn't found as the bullet. However, they couldn't exclude it either, and they failed to mention that part.
Yeah.
Thank you, Judge, for pointing that out.
So he might deny it and grant it in part. I don't know.
It could go either way at this point. I'm not really sure. Like, I don't think the prosecution did any wrong.
I was say usually I can pick up on where he's going. I can't.
I just know her.
You did. You almost got a stopwatch again. Oh, is that what that was? Yeah, that was Russian. She changed to the Russian keyboard. So,
What again?
so
Russian communication.
I mean, are they deliberately? Is he going through everything to make sure that everyone understands what direction it's going to go for them as individuals or as a defense and prosecution?
Yeah, and he's also, as Volusia once said it, making it appeal proof.
Yeah, trying to.
Because he knows how this is going to go already. They're going to go over his head as soon as they're able to.
Gwen's least favorite judge also did that. She talked for about 20, 35 minutes straight.
I just like it's bad enough. Like I'm a straight to the point kind of person. Yeah, I have a little ADHD and we get off topic and we talk about things, but we still make a point. There's never one stream where we don't make a point and then we move on to the next point and then we move on to the next point.
It's
and
called
like,
bringing a little bit
this
of humor.
much time on one point. I'm like,
at the end of the day, if you're going to sit on your platform and fucking, excuse me, and freaking sit there and talk in monotone and go on for an hour and a half, no one's going to enjoy it, are you? So if you want realism, entertainment, a little bit of banter, and a little bit back and forth, because that's, that way, okay, you're getting a break in between the periods where you're listening, so you don't go into zone out or you don't go into like an open-eyed coma. You actually sort of, pardon?
Sometimes I feel like that watching trials.
I mean, like yesterday, we were talking for 3 hours. You know how many times this lady interrupted me while I was having an important diplomatic conversation?
All the time.
Fucking, yeah, at one point, what did I say to you?
Shut up.
I actually said to her, I went, Squid. He went, what? I went, shut up. And then carried on. You know, and the thing is,
While you do that, I have to go do mama duties.
Right. We can talk about the topic. We can come with our opinions, and you're hearing it. So you've got your opinion. And even if we're going off the chat and off each other, there's interaction. That there brings life to it.
Yeah.
Sitting there going, hello, welcome to the stream. We are now going to talk about court. We are going to listen to people who are sitting in the court. And at the same time, we may pause and go for a beat. We are going to do this. And at some point, I will breathe and carry on talking. At some point, I may not talk because I probably might be unconscious due to the lack of oxygen in my system. You know what I mean?
Or some people, they just put the court feed on and let it run. I thought it was wrong, but some people get away with doing it. I'm like, how?
Yeah, I mean, like with some cases, you can do that because the thing is, you don't, like some cases can be that technical where, you know, and at the same time, when you're doing replay, if someone doesn't understand something, they can go back and then play it again.
Yeah.
You know, when you have breaks, when we're talking about, like, he's going through everything.
Yeah.
Right? Their behavior, the way they're acting, you know what I mean? And the thing is, having natural breaks where we're like bouncing off each other or we're talking about what do they say in chat, right? It puts that natural break in between in the stream.
Yeah.
You know, because one thing I've been doing, like in mine, I've been neglecting, so that's why I interact with the. But with this, you've got, instead of just the chat and us, you've also got a third party, which is the video. So, and that's got a lot of information.
All right, you ready to start doing this again? We have 25 minutes left.
Oh wow.
The media seized on this omission, generating headlines that materially overstated the forensic conclusions, stating the bullet did not match the rifle. The court finds Mr. Ballard testified credibly that he viewed this media narrative as highly prejudicial to the state. Legal analysis. Rule 3.6c permits a lawyer to make a statement that a reasonable lawyer would believe is required to protect a client from substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer. A false media narrative asserting that the murder weapon has been definitively forensically excluded constitutes substantial undue prejudice to the prosecution. Mr. Ballard's statements explaining the forensic mechanical definition of an inconclusive test were narrowly tailored to mitigate this specific prejudice. While comment 5 generally prohibits discussing the results of the test, the safe harbor of Rule 3.6c authorizes otherwise restrictive, responsive statements only to the extent reasonably necessary to mitigate the recent prejudicial publicity. Conclusions on Allegation 1. The court finds Mr. Ballard's statements clarifying that the ATF's inconclusive findings were protected by the safe harbor provision of URPC 3.6c. These statements do not constitute a violation of the publicity order. Contempt is not proven regarding these specific statements. Allegation 2, the statements opining on the strength of the evidence and guilt. The conduct. Beyond merely correcting the ballistics record, Mr. Ballard provided the following statement to TMZ. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing. And then we will present all of that evidence at the trial. He further stated, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence. Supporting evidence. The published TMZ article dated March 31st, 2026. The state does not deny these statements were made. Contrary evidence and defenses. The state relies on State v. Wright, a Kansas case, arguing that a prosecutor's general statement that his job is to bring cases he believes he can prove beyond a reasonable doubt does not express an improper opinion on guilt. The state argues that merely expressing confidence that it has enough evidence to carry its burden tells the public nothing more than what the existence of the prosecution already proclaims. Factual and credibility findings. The court finds that Mr. Ballard subjectively believed he was operating within the bounds of Rule 3.6. However, the court finds that his subjective belief regarding these statements was objectively unreasonable. Legal analysis. Rule 3.6c strictly dictates that any responsive statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. The adverse publicity here concerned one specific piece of physical evidence, a bullet fragment. The court does not conclude that Rule 3.6c prohibited all public response. To the contrary, Rule 3.6c expressly recognizes that in limited circumstances, counsel may respond to recent publicity not initiated by the lawyer or lawyer's client. The question is not, therefore, whether Mr. Ballard could respond, but whether a reasonable lawyer would have believed the additional statements concerning the overall strength of the prosecution's evidence were necessary to mitigate the specific prejudice created by the inaccurate reporting concerning the ATF examination. The court applies an objective standard. The subjective good faith of counsel is relevant to credibility, but does not determine whether Rule 3.6c's limitation was satisfied. The state's reliance on State v. Wright is misplaced. Wright is distinguishable because it addressed statements made during voir dire rather than extrajudicial statements governed by Rule 3.6. As the Utah Supreme Court recently reiterated in Levitt, when an elected prosecutor or their deputy makes public declarations regarding the strength of evidence or their belief in ultimate outcome of the trial, those words carry particular weight and authority of the government. Stating that the prosecution has ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder reasonably communicated to the public the prosecutor's assessment of the defendant's guilt, that the defendant was guilty. This directly violates comment 5, Roman numeral 4 of Rule 3.6, which prohibits expressing any opinion as to the guilt or innocence of a defendant. While Mr. Ballard offered a cursory nod to the presumption of innocence, he immediately undercut it by publicly broadcasting his belief that the state will overcome his presumption of innocence. These statements were not reasonably necessary under Rule 3.6c to mitigate the confusion surrounding the ATF report. Rather, those additional public statements possessed a substantial likelihood of materially prejudicing the proceedings by communicating the prosecutor's assessment of the defendant's guilt. Conclusion on allegation 2. The court finds that the statements to TMZ regarding ample evidence and overcoming the presumption of innocence violated Rule 3.6a and were not protected by Rule 3.6c safe harbor. Because Mr. Ballard knew of the order, possessed the ability to comply, and intentionally made the volitional statements in question, the elements of civil contempt are proven by clear and convincing evidence.
Wow.
The state and the UCAO possesses vital First Amendment interests in communicating with their constituents and defending the integrity of their investigation against false media narratives. Rule 3.6c accommodated that right by allowing Mr. Ballard to correct the inaccurate ballistics narrative. However, the defendant's Sixth Amendment right to a fair trial places a constitutional ceiling on prosecutorial speech. As the United States Court held in Gentile, a lawyer's right to free speech in a pending case is circumscribed because lawyer statements are likely to be received as especially authoritative. In capital cases where life is at stake, the court concludes that defendant's Sixth Amendment interests is predominant under these facts. The court's ruling is not based on disagreement with the prosecutor's viewpoint, nor on the mere fact that the challenge statements were made publicly. Rather, the court enforces a pre-existing publicity order that incorporated Rule 3.6, applied equally to all participating counsel, and governed attorney conduct in a pending capital prosecution. The contempt finding rests on the conclusion that the identified statements exceeded the objective limits of Rule 3.6c, not on the content of the state's position or the court's assessment of the merits of the prosecution. The remedial measures ordered are directed to preserving jury impartiality and future compliance with the court's order. Thus, the application of civil contempt sanctions here does not offend the First Amendment. For the reasons stated above, the court independently determines that the movement has proven by clear and convincing evidence that Deputy Utah County Attorney Christopher Ballard is in civil contempt of the September 16, 2025 and December 15, 2025 publicity orders. The court emphasizes this ruling does not address the merits of the criminal charges, the credibility of anticipated witnesses, or the ultimate guilt or innocence of defendant. Its sole purpose is enforcement of a narrowly tailored publicity order governing attorney conduct. A reasonable attorney invoking Rule 3.6c may respond only to the specific prejudice requiring correction. The prejudice identified here concerned the public misunderstanding of the ATF's inconclusive forensic finding. Once that misunderstanding had been fully addressed, further commentary concerning the overall strength of the prosecution's evidence did not materially assist in correcting specific misimpressions. Rather, those additional statements induced a separate subject, the prosecutor's assessment of the ultimate merits, which Rule 3.6 independently regulates. Conclusions of law. First, the pretrial and trial publicity order entered on September 16, 2025 and amended on December 15, 2025 was a valid, clear, and unambiguous lawful order of this court. 2, Deputy County Attorney Christopher Ballard had actual notice of the order, knowledge of its contents, and the unhindered ability to comply with its directives. 3, although Rule 3.6c permitted limited responsive statements explaining the ATF report, Mr. Ballard's additional statements concerning the strength of the state's evidence and anticipated ability to overcome the presumption of innocence exceeded the scope of that exception and violated the court's publicity order. 4, Mr. Ballard intentionally and volitionally made these extrajudicial statements, fulfilling the required elements of civil contempt pursuant to Utah Code 78B-6-301, sub 5, and Von Hake v. Thomas. Order and sanction. Having found Mr. Ballard in civil contempt, the court turns to the imposition of sanctions. The defendant argues that the appropriate sanction to remedy this prejudice is to strike the state's notice of intent to seek the death penalty. The court declines to adopt this requested remedy. As the
Okay.
state correctly argues in
I
its
mean,
objection, striking a capital
Okay. So we just gotta stop it right there. We've listened to a lot because there was no need to stop him during that.
Yeah, because he was at the crux of it, the crux of the ruling.
Yeah. So civil contempt. He's going to sanction him, and however, he is not going to do what the defense wanted him to
And that's
do.
what the state argued at the last hearing, if y'all remember. They argued that, okay, even we're not saying that we violate anything, but if we are in contempt, it's civil contempt. Taking capital punishment off the table is criminal contempt. It doesn't make sense.
Yeah, it's just one of those situations of like,
So they're probably gonna have to pay a fine or something or the other.
I'm interested to see what the sanctions will be. I mean, because the judge does have a lot of leeway. However, this is one of those things of, will the defense take this as a win, or will they take this as a loss and keep trying to fight losing battles? The judge is obviously not going to take the death penalty off the table unless it's
A serious violation.
yeah. And talking to the media, and I'm still
I'm surprised
this is
he
where
found
I'm
him at
torn
contempt. I'm
because
not-
I see the judge's point, but I don't necessarily agree with it.
I'm surprised he found him in contempt.
Yeah.
Wow.
And hey, Dan, I don't yeah, what's that with the judge being prejudicial and allowing cameras? Like, it's like Kathy
He
Nestor tries to play that this is they're prejudicial by allowing cameras when she just came off of a trial.
He's still gonna have to rule on that because they filed that in the preliminary, and let's schedule another hearing for next week. The preliminary in July 6th, and they do have motions to.
Can we use the DP with the lawyers? Sometimes. I mean, sometimes you're like, I know that the defendant did the crime, but can the lawyers do the time?
What was it? It was some video game they had, and they had like a culpability act where if your client is found guilty, you also found guilty, and you had to suffer the same punishment.
Oh, hell no.
I'm like,
no, because no one would ever be entitled, because everybody's entitled to a defense, whether you are innocent or not. So if you know, okay, here's the thing. If you know your client is most likely not innocent, like a Daryl Brooks, shall you say, how do you...
If those rules existed, nobody would ever take cases because I'm
nobody would ever... I mean, I sure as hell wouldn't. Not that I'm a lawyer, but if I was,
being like, this person is facing capital punishment. Also, under the culpability act, you face the same punishment. Like,
the thing is, at the end of the day, if you're going to bring capital excuse me a second, because that fucking voice that droning of him talking nearly made me fall asleep. Right. Yeah, I'm literally sitting here and I'm like fucking doing a noddy dog, and I'm like, why the fuck am I tired? And then it realized it was listening to him. If you're going to bring in capital punishment, then you need to do it straight from the fucking get-go. It has to be it needs to be on the table from the get-go so everyone knows where they stand.
Yeah,
but the problem is, with the media involvement, but now this is like all over the fucking shop in the media, right? You're going to get these snowflakes going, oh, he didn't. Yeah, sorry. If you're going to bring
capital punishment when the case first started, the defense is that's going to be their victory is
Jeffrey
get some life in prison.
Let's not start.
Capital punishment.
Enhancement or reducing the charge is not a remedial civil sanction. It is a fixed, absolute, and purely punitive sanction. Such an act would cross the threshold into criminal contempt sanctions and would also risk an improper judicial intrusion into the executive branch's prosecutorial discretion. Civil contempt sanctions must be remedial, tailored to cure the prejudice caused by the violation, or designed to coerce future compliance. The court finds that striking the death penalty is grossly disproportionate to the misconduct and legally unavailable in this civil contempt framework. Before imposing sanctions, the court considered whether a mere finding of violation
Dude, I thought I had RBF. Stacey Visser is like she does not have a poker face. Whereas the two prosecutors on the bottom, the county attorney in the middle, and this guy, I cannot remember his name to save my life, Grunander.
Oh yeah, Chad Grunander.
Jeff Grunander, I
Chad.
think.
Chad.
They're just sitting there staring. I know that they don't agree with it, but their faces really haven't changed that much.
Yeah, because they technically lost, but
But
maybe it's a recording.
Is up here going.
Maybe it's a record. I mean, she like either she slipped on some powder. I mean, she's been acting really weird. I've been watching her.
I think she's always really weird. Like she just strikes me as a really weird person to begin with.
Yeah.
However,
she's the only other Utah attorney had besides Nestor.
Mm-hmm.
And here's the thing: when it comes to what we were discussing before, capital punishment, right? It needs to be an open book when it comes to that. It needs to be right at the get-go.
And they were.
Right. So where's the problem then? Because I've heard it come up, unless I'm misinterpreting what's being said.
The defense was trying to get capital punishment removed from the table as a sanction.
As a punishment. That's going to be their ultimate goal. Since it seems like there's all this evidence against him, their victory is going to be getting him life in prison. That's going to be
got you.
So the where the death penalty comes into play is that's what the defense wanted as a sanction for the prosecution, to remove the death penalty as an option.
Right. So what is the penalty there? Is it shooting, electric shock, drag?
I think it's
injection.
I think it's injection.
Yeah.
Lethal injection, right?
I think.
So they don't gas anymore, no?
No, that was 1930s.
That
was a German thing. That was not an American
well,
thing.
They used it here because Manson would have went there if he would have.
True. A couple states do allow. I know South Carolina, I think, allows firing squad.
Oh, I'd love to do that. If I had to go, yeah.
Idaho also has firing squad because that's Chad Daybell and Coburn was potentially facing if he would have went to trial.
I mean, that's the quickest. Like,
or like if they get sentenced to death, put them on a like a 600 meter range, and target will fall when hit. You know.
I mean, the death penalty is the if you're going to do it, that's the quickest.
Well, yeah.
I want to look up. Do they still do mass meals?
Gas chamber was used in California. Maybe it's Maybelline.
Yeah. I'm just to finish off with the capital punishment. I find it a bit strange that a few states have it and other states don't. I mean, wouldn't it be like a better idea to every state have capital punishment? You know, in regards of murder.
Welcome to why we have 50 states and not one.
I guess there's certain states that don't have. I don't. Well, DC not a state. Georgia doesn't have it.
Georgia. I don't know if Georgia has it. I don't think if they do, they don't use it very often, which is weird to me. But
yeah, because that's another state. Because states like Mississippi and Alabama apparently use it.
Texas tried to put in an express lane a few years ago.
Oh wow!
Wait, what?
Texas tried to put in an express lane. If it was like, I can't remember. It was a joke that was in a Ron White comedy thing, but I looked it up, and I guess there was a bill, and it was like if certain amount of people saw you commit the crime, like you did it, you walked up and just shot someone, and so many people saw you do it, you didn't really like it. They tried to make the process quicker.
You don't need a trial, just go right to punishment.
They tried to make the process a little faster.
That makes it that makes sense for Texas, because Texas, I think, is the highest state that uses capital punishment.
I can see that. Like, I don't know if that law ever went through, but the running joke is Texas tried to put in an express lane while other states are abolishing it. Yeah. I think his punchline was, if you come to Texas and unalive somebody, they'll unalive you back.
Oh wow.
You
Sounds
know, would it be cruel punishment if he had to sit at a table in the middle of a crowd of people and wait for? Yeah, that would be.
Do you know
But-
what? That would be the
There we go.
awesome idea. The
Georgia
only
has a
problem
death
is,
penalty state, but requires aggravating circumstances. But I don't know if I'd want Georgia to use the death penalty with a few cases that I've seen there lately. I'm like, no,
Georgia, yeah,
I don't want you to have that power because you suck at your job.
yeah, Georgia, especially with cases like Edric Faust and stuff like that around. Yeah.
Where I'm like, that shit don't make any sense. Even as a cold case, that shit doesn't make any sense.
They had a case where it was supposed to start a couple of weeks ago in Georgia, but it had to get postponed because the juror did use Chat GPT to look up the facts of the case before they were sworn in.
That's dumb.
do you know, that's not a bad idea, actually, thinking about it. You know, if how you take your victim is how you go.
That's what I always said. That would be.
That would be
Yeah.
perfect. And also the person who
Can we
the
not get my
person-
channel demonetized though, please? Because
No.
this is how I feed my family, and we can't afford to.
All right, okay. I'll
not,
just mute myself.
Oh, I could talk about this all day, but YouTube doesn't like me talking about this topic very much. So, you know, what I want to do and what YouTube wants me to do, or
Doesn't always line up.
yeah, that's that right there. So we're gonna talk about this.
If I become a Twitch streamer, now I got to figure out how to about rules and regulations, what I can and can't do.
In Alabama, we have 3: electric chair, lethal injection, and hypoxia. Hypoxia. That sounds like cruel and unusual
I'm
punishment.
trying to remember what that is.
Lack of oxygen.
Oh. Okay, yep.
That sounds like cruel and unusual punishment. I mean, just a
Wow, and I didn't know any states still had it. So they just
Heidel is doing some things. By the way, just in case. Yep. So, I believe firing squad is in 5 states. Interesting. I'll have to do some research on that. Research that's not going to get me YouTube yeeted.
Let's see.
Because I could talk about that all day, but YouTube does not. Yeah, is it necessarily though? Like, because hypoxia could be a lot of things. So
Violations without remedial
from a
measures
medical
would
standpoint,
adequately protect the integrity of future proceedings. The court concludes it would not. At the same time, the court rejects punitive sanctions that would intrude upon prosecutorial charging authority or materially alter the underlying criminal proceedings. The selected remedy addresses only the potential effects of the publicity on jury selection and future compliance with the court's order. Accordingly, the court concludes that relief ordered constitutes the least intrusive means reasonably necessary to remedy the identified prejudice. However, the violation requires a meaningful remedy to compensate the aggrieved party and protect the integrity of the impending trial. The court draws guidance from the remedies deployed by the district court in Leavitt to cure jury pool taint. Therefore, it is hereby ordered. The defendant's motion for an order to show cause for contempt of court is granted insofar as the court finds Deputy County Attorney Christopher Ballard in civil contempt. Enlargement of jury veneer to directly remedy the potential taint introduced into the Utah County jury pool by Mr. Ballard's statements regarding the strength of the evidence. The court will consider expanded voir dire procedures, additional jury questionnaires, expanded jury summons, or other remedial measures as necessary after consultation with the parties' attorney's fees. Because this civil contempt proceeding was necessitated by Mr. Ballard's violation, the court shall compensate the defendant for the reasonable attorney's fees and costs incurred in the filing, drafting, and litigating of the motion for order to show cause and the evidentiary hearing. Defense counsel is ordered to submit a detailed affidavit of costs and fees within 14 days of the order of this court. The state shall have 7 days thereafter to file any objections to the reasonableness of the requested fees.
Okay,
Future
so they got
compliance. The court reaffirms.
yeah, I just find it interesting. I don't think the defense is going to be happy with this whatsoever.
Oh,
They're
no.
gonna bitch. They're gonna moan. They're gonna put in motions, which we will read.
Yeah.
Ugh,
This
I
is
haven't
this
bothered to read any of the motions that have been going on with these hearings
most
because they're hearings.
most of the motions are deemed what they call it moot at this point because it's just
Yeah.
objections to them removing capital as a sanction, and that's he already done it. So
Well, yeah, and I haven't bothered to actually read any of the motions that are being discussed here because they're being discussed here. Like,
yeah.
I don't like redundancy like that when I got other stuff to,
Yeah.
you know what I mean? Like, when I got other stuff to talk about and we got multiple things to worry about,
Yeah.
talking about reading a motion and then hearing them talk about it for 3 hours,
Yeah,
I could
just
think
like
of better things to entertain
I don't
myself
read the
with.
camera motion anymore because every hearing they're gonna file motions to exclude camera. So I'm like,
Yeah.
he already had it, so it's probably just gonna be another denial anyway.
It's like, figure that shit out. Like, stop doing it. You're not gonna change the judge's mind. Stop wasting time, effort, and money.
Yeah, if they were in another state
The
like
existing-
Florida, the judge would be like, "You're finished." The motion I've already ruled. Let's move on.
It just it's stop. Yeah. I get it. They're never gonna be happy, but at the same time, they're picking battles that
Now people
make
said, and I don't know, like I said, I didn't get into that case till very, very late, till like when the plea deal came up. But people said they think they're trying to do what Koberger tried to do. I guess Koberger tried to delay, or it looked like he was trying to delay and stuff until he got that deal. I don't know. But
I don't know. It's just one of those situations where, like I said, not a lawyer, but for the sake of argument, my toddler, there are some things I'm willing to fight it out with, and there are some battles that I'm just not willing to pick because they're a waste of everybody's time, effort, and energy.
you like, ain't nobody got time for that.
They are fighting this like a toddler. They are picking every battle like it's the end of the world.
They're fighting like their life is also on the line. Like, gee.
It's just one of those situations where you just look at it and you're like, I understand you have to fight for your client, but why that battle? And why that battle every time?
If I'm them, I would be trying to forget about the cameras. I'm trying to file to get a lot of this evidence suppressed.
That's the thing. Instead of trying to get evidence suppressed, they're fighting for cameras in the courtroom. That's the battle that they are choosing to pick, and not trying to get evidence thrown out. That's where I'm like, your emphasis is in the wrong place here, honey buns. That's what I can't understand, and I will never understand about certain stuff. And maybe I'm just weird, which is potentially the case because I'm just weird. However, like, pick your battles, but pick battles that are going to be effective and worthwhile.
Cause I'm
You
like,
pick
they
a
got
battle
all
that
this
you're going to lose
evidence.
every time.
Cause I'm like, there's all this evidence against their client. You would think they're like, yeah, we need to fight to get some of this stuff out.
Instead of trying to keep out what the public sees of the evidence that is presented in court, how about we try to get that evidence not admissible in court?
Yep, and that way nobody be able to see because the court would have already ruled like it can't come in. So
it's just it like the emphasis is in the wrong place. They are fighting a battle that they are never going to win. Instead of picking battles that they might have a realistic chance of getting a win, they are picking a battle and trying to get this cameras thrown out of the courtroom every time. It's like, why are you trying to hide? If your client is innocent, why are you trying to hide? Wouldn't you as the defense want to see, hey, look at the prosecution, look what the fuck they are doing to us? But instead, they are trying to pick this battle that they never, ever are never going to win. She is adorable and I love her to death. However, she is a toddler and she loves pushing boundaries. And that is her thing. And sometimes there are boundaries that I'm willing to just, it's not worth the fight.
You not like my mom always had. She could give you the look, or she just say your name a certain way, like
Oh, yes, when she is 4, 5, 6, of course. When her brain is more developed and she can understand like, right now, she doesn't understand the reasoning for why she's being told no, so she keeps pushing. Like, when you tell a 3-year-old something, they're going to just do it because they're going to push that boundary. If she is safe, and sometimes there are just boundaries that I'm just like, "Whatever, child. You are going to find out the hard way why I told you no." Ha we're in the find out stage of the FA-FO equation. Like, but then there are some battles where I'm like, "No, this is a safety issue. I need to pick this right now," and she will throw a hissy fit. However, it's picking battles that I believe I can win and that are
yeah.
effective and that are necessary. I think this I think this order to get cameras removed from the courtroom every time, or this motion that they keep filing,
I mean,
this
yeah, like I
effort that they
could
keep
see.
making to get cameras removed from the courtroom every time is a waste of time.
Yeah, I mean, I could see if he had granted one hearing to be closed, then you're like, oh, well, it's working. Then foul it, but they fouled it. He denied it every time. You would think, like, all right, this ain't working.
Yeah, like this morning, I told her not to run in front of the door at grandpa's house, and I opened up the door, and
Woo!
she was running in front of the door, and I didn't mean to. I didn't know she was going to run in front of the door when I opened it, but oops.
Yep, I've been there before.
And it was like, well, now when I tell you to stay in one spot, now you know why, because I'm going in and out of the door, in and out of the door, and I don't want to hit you with it.
My mom used to be like, don't go in the kitchen while I'm cooking. And I'll go in the kitchen anyway, and I got popped by grease. This, see, you got to learn yourself. So I tried to warn you.
Yeah, and Gail brings up a really good point. Look what keeping cameras out of Texas got you.
Yep.
Yeah. And that's another whole nother rabbit hole that we don't have time for, but like
So Anthony said, yeah.
it's just
Problem is you can't please everybody.
that's true too. I just think they're picking battles, and I think they are going to keep fighting this death penalty battle.
Oh yeah.
Until
this thing's gonna drag out for years.
Yeah,
I think this goes to trial in 2028.
Yeah.
Right, I just done some research while you guys were talking, hence why I was quiet. In regards of cameras in court, and I've got two different variations here. Cameras can help tracking movements, like see doorbell, dash cam footage, and everything else. Identifying suspects, collaboration or corroborating statements. The limitation of risk, poor quality, misleading context, time sensitivity, and it can't, obviously cameras in court can't be used. I just think that like it's a double-edged sword, really. We've gone over this before. It's a double-edged sword. Sometimes it could be beneficial and help the case, but in other ways it can't. And the thing is, when you do stop cameras going in, look what happened. Yeah, Texas, but that's people who are not satisfied, and they just throw hissy fit, and then suddenly it's like Channel 1 News, or So, as far as I'm concerned, cameras shouldn't be in court because they can be a bad influence on the case itself.
And see, I'm opposite. I think they should be in every courtroom.
Yeah.
So one, we can hold our elected officials to make sure they're doing their jobs.
And then,
but when it affects,
if they are trying to hide shit.
Here they're kind of hypocritical, because here they argue, well, we don't want camera, but then they'll argue the media is spreading misinformation about our client. That well, if the cameras aren't there, what do you think gonna happen?
I mean, the thing is, having independent journalists in a courtroom with no cameras, and like at the end of the day, you then have to put the trust in the journalist.
But see, I don't. Yeah, that I have to put my trust in other people, and we all know how bad I am at that.
Well, that's you. What about the other 359,999,000,000,050,000,000?
A lot of people don't trust anybody else either. So you have to see it with your own eyes to realize what actually happened.
Right. Well, maybe that is like looking at it like, okay, here we go again, devil's advocate. Right. At the end of the day, you can't satisfy everyone, and that and you can't please everyone. But when it comes to a case, especially like this, there has to be a there has to be a DMZ where they need to do their job, and the public need to wait until they have done their job, and that goes to both sides. I mean, people may not agree with me, but I think that sometimes cameras can be a really bad idea in courts because don't forget witnesses, jurors.
I believe that witnesses should have the option of whether they should be on, whether they get to be on camera. Jurors are never on camera, so that's not a problem anyway.
We saw that in the Pike County case in Ohio. Multiple witnesses didn't want to be televised, and the judge granted it.
Yeah. I mean, that's a civil right in it. So if you don't want to be, I mean, like, I just think it's a double-edged sword, really.
Yeah, but the only way to hold people accountable and making sure there's transparency in our court system and making sure that defendants actually get a fair trial and don't get screwed over by the prosecution and the judge, because at the end of the day, the prosecution and the judge are both actors of the state, is to record everything.
Then it has to go across the board. Fire stations, ambulance stations, hospitals, police stations, cells, the lot.
Well, cells I agree with. Fire stations and stuff, I don't necessarily agree with, because you might get people who go get a bowl.
No, I don't mean like, I think I know where you're going to go about the drop off areas and stuff like that. I get that.
So,
but
all right, we got to get back into.
Also, I looked up for Utah. Their method for capital punishment is lethal injection and a firing squad.
Firing squad, definitely the way to go.
Their primary is lethal,
unless they have really bad shots.
In the
firing
secondary
squad with a Carl Gustav.
Yep, the secondary they don't use firing squad if they don't have enough stuff for the injection.
Yeah, I call for firing squad with the Carl Gustav.
Clear bowl. No. Why are we fussing? Go get daddy. Go get grandpa. Go get somebody.
That's a good point, that.
Well, that's what I agree with that. Where's your father?
Or 50 cal.
Where's your grandfather? He's home too. Like, she brought me a bag of frozen strawberries.
Oh, bless her cotton socks.
Well, when we went to pick strawberries, I froze a bunch of them. I made some of them into frozen yogurt bites. I made some of them into popsicles, and I froze some of them because we had 10 pounds of strawberries. And when you pick them fresh, like hell is that strawberries from the grocery store. Sometimes if they go bad, I'm like, yeah, whatever. They were grocery store strawberries. Like, shit happens. But if I'm picking and paying to pick strawberries myself, where they're fresh and they're the best quality strawberries because I'm picking them myself, like hell am I letting them that go bad. So
I miss strawberries. I'm allergic, unfortunately.
No, I don't like strawberries, but I'll tell you that I'll tell you some other time why. But yeah, I mean,
she'd turn into a strawberry if I let her.
Yeah, all right, firing squad. 3 choices: 50 cal, Carl Gustav, or Jimpy.
Give me some Tannerite. Maybe go over there, and over there. Anyway, let's get back to the sanctions.
Yeah,
because I don't think they're going to be happy with because that's what the prosecution offered them. More blood ire.
I think he's leading up to
questions.
I'm just waiting for them to file an appeal.
I think the judge is like slowly taking him to the point where he's like, instead of just throwing him in the hole, he's like, "Come on, sweetheart, let me just help you."
One day he gonna snap and be like, "I've already ruled. I can see it coming."
So Buffed Old Man said fresh strawberries and rum. Buckshot said strawberry flavored vodka. We don't have either one of those. We don't have any alcohol in our house.
You two are just
like
old.
4 cans of beer that don't belong to me. So those belong to my dad.
It's typical. That is typical freaking old school. That rum or vodka, freaking old
Well,
git.
I'd like to roll around in strawberry jam.
Drink
Wait,
the whole
what?
English.
What? Spawn like to roll,
She
darling.
might come after him with
Right,
the
darling.
cast
Right,
iron
listen to
pan.
this. Listen to this. Spawn like to roll around in strawberry jam with his significant other, hence not talking about in string. Are you up for it? You're not up for it. Apricot jam. Okay, I'm up for that. I'm up for that. Yeah. See, Volusia? See? Listen, me and my beautiful queen, we have got such a good sense of humor.
Volusia, you don't know what you started. Hey, friend.
Don't
Anyway,
you worry, he'll get it.
Anyway,
Publicity
everything
order.
just started.
Any future violation may result in additional contempt proceedings and sanctions authorized by the law. Courts depend upon public confidence that criminal prosecutions will be decided upon evidence presented in open court rather than public advocacy outside of it. This order should not be understood as discouraging legitimate public communication authorized by Rule 3.6. Rather, it reflects the court's obligation to enforce a previously entered order equally against all counsel and to preserve the fairness of the proceedings for both the defendant and the state. And this concludes the ruling of the court. Again, this will be uploaded to the docket before the end of the day. Counsel, let's move on. Turning to defendant's oppositions to EMC order for the preliminary hearing.
The cameras rule.
The court will issue a written ruling by midweek next week. The court recognizes that both parties are actively preparing for the preliminary hearing scheduled to begin on July 6th. Given the time and attention required for that preparation, the court does not believe an oral ruling on the motion is necessary. The written ruling will be uploaded to the docket, and parties will receive notice once the court has issued its decision. Turning to the upcoming preliminary hearing, the court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor.
Bro, you said that.
Portable electronic devices include any device that can record or transmit data, images, or sounds, or access the internet, including a...
Huh?
I was saying, he said that last Thursday or whatever the last hearing was.
I feel like he repeats himself a lot. Here's my thing, and I'm sorry, I'm eating a frozen strawberry, so bear with me. I'm eating on camera. Get over it. It's a strawberry. However,
I'd be eating barbecue on camera.
Make sure you swallow.
That's what she said. Anyway, well, technically that's what he said, but that's not the point. Okay. I forgot what I was going to say.
Something about
welcome to my world when you do it to me. Touche.
Well, it's the thing. Yeah, he repeatedly says the same thing. It's almost as if he realizes he's not talking to people who act like adults.
Maybe I wonder if he's related to Judge Grudge.
No.
Right, good.
Here's the thing, though. Like, I'm wondering if he's having a Belitho moment where he realizes that he's not talking to adults.
Yeah.
Like, he's not dealing with people. He's dealing with people who look like adults, but their frontal lobes no longer act like adults.
Which
Nice.
I don't know how half of these attorneys persisted since they've been attorneys for decades. Some of these attorneys been attorneys since the 70s.
Fucking hell. Half of the people in this chat were not even born then.
I wasn't even born yet.
Well, you're the youngest one here.
Yep.
Like, you're the youngest one in
Yep.
chat in general.
Yeah.
So
I wasn't born before a lot of things.
what year were you born again?
2000.
Oh my god. Oh my god. Oh shit. What did I do? Oh wow.
Yeah.
Yeah. No. Don't ever swear in front of me like that again, Flashman. I will tell your mum.
Good luck. She ain't around.
That was dark. That was dark.
I say
Flashman.
if you can.
That was dark, Flashman. That was dark. That was really dark.
Yeah, no. I was waiting for you. I was very tempted to say something, but you said it first.
That was very dark humor. I knew.
I didn't know I had that in me.
I did.
Oh shit!
A lot of us see things in you that you don't see in yourself, and that would be one of them. Your sense of humor. All right, let's get back to this. Yes, he said 2,000. You heard that. You don't need to wash out your ears.
Yeah, no, it's true.
You heard that right. My knees cracked when he said that.
I was surrounded by boomers. And I just made the entire chat bad.
Yeah. I felt my back pain increase when he said that. Yep. All right. Getting back to this because we got less than 10 minutes left.
Pager, laptop, notebook, personal computer, handheld PC, PDA, audio or video recorder, wireless device, cellular telephone, electronic glasses, or an electronic calendar. This prohibition does not apply to legal counsel and support staff for the defense or the state in this matter, or the equipment permitted under any controlling electronic media coverage order. In addition, every person who will be in attendance will be afforded the dignity and respect due to them, and pursuant to the September 24th, 2025 Standing Decorum Order, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, and shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons.
And that's why we watch online, because I can do whatever the hell I want within YouTube terms of service. Within YouTube terms of service, YouTube overlords.
I would love to go to a trial in person though.
Have you seen Jeffrey? One of us.
Nope.
Signs, clothing, or photographs expressing support for or against any person related to this case or the status of this case as a capital offense. Members of the media and public will be permitted in the courtroom subject to available seating. A limited number of seats will be reserved for each group and will be made available on a first-come, first-served basis. The court respectfully asks all persons seeking admission to conduct themselves in an orderly and respectful manner while court staff and security personnel carry out their responsibilities, including security screening and the assignment of wristbands for entry into the hearing. Counsel, does either party require the benefit of the record?
Yes, Judge. Mr. Grunander for the state. A question. I know this order does not apply to legal counsel for the state or the defense or our staff that are there assisting us, but would the court permit counsel for the victim's representative to keep his phone on his person?
To defense, any input?
We have no objection to that, Your Honor.
Oh, what a surprise.
Right.
No,
Mr. Grunander, based
First
off
time
no
hearing it.
objection and finding it is in the interest of what is permissible, I will grant that request, and I appreciate that clarification.
Thank you. And then I have one other item that goes outside of this particular order, Judge, if you're ready to hear it.
Yes.
There may be some sensitive information that is presented during the preliminary hearing. And the state would like to be able to alert the court before that happens to allow for members of the victim's family to exit the courtroom prior to it being presented in the court. We anticipate turning the monitors away from the gallery, but there will be some audio that could be sensitive nonetheless. So we would like to inform the court that we would like to alert Your Honor before that happens to allow for them to exit the courtroom. And then once that is presented, allow for them to return to the courtroom. That would be the state's request.
Thank you, Mr. Grunander. To defense, did you want to respond?
It doesn't seem like a response is necessary from us, Your Honor. We think that's up to the court, how the court wants to handle that.
Thank
Whoa.
you. Pursuant to Article 1, Section 28 of the Utah Constitution
Yeah,
and subsequent
I see.
Utah law, victims are entitled to be treated with dignity and respect. And I find that this request falls squarely within that, and I will grant that request. Counsel, just as soon as you can, as soon as it is upcoming, feel free to alert the court, and the court will take a brief recess to allow victim representatives and to make that decision if they wish to.
Photos from the autopsy. So what kind of sensitive information or replay of the video that was being passed around the internet for
I
weeks?
believe in a previous hearing, I don't know if it wasn't last hearing, but I want to say the hearing before the last hearing, said that the state did say that, because I streamed that for it was about 2 hours. I believe the state said that there's going to be some body cam footage and videos of him being
Moved.
unalived.
Yeah.
And that's
I'm
part
sorry.
of the
I'm
stuff.
throwing these in my lemonade because it's hot.
the strawberries.
Why not?
But yeah, that I don't know if they're gonna show pictures, but they're gonna have a video of.
No, hang on a minute. Before you do, I just have to say something, so also my wife can hear it as well. She's sitting here eating strawberries, darling, without cream.
Oh my goodness.
I know, sacrilege, heresy.
I could put some whipped cream on it, but she didn't bring me whipped cream. She
Yeah, that's what she said. Sorry, I couldn't resist that one.
That leave the courtroom, they may do so. And then after that evidence has been presented, they will be allowed to return. So we'll take a recess after that sensitive material, as you've defined, is presented. And just if you could alert the court, so a brief recess could be taken to allow them to come in to ensure that they are able to be fully present for as much as the preliminary hearing that they choose to participate in.
Perfect. Thank you, Judge.
All right, turning to defense, do you require the benefit of the record or wish to bring up any additional items?
Your Honor, Michael Burt for Mr. Robinson.
All right, Mr. Burt.
Judge, at the last hearing, I indicated to the court that we would be seeking a ruling from the court prior to the hearing concerning some expert witnesses that the defense had subpoenaed from out of state. And after discussions with the state, it appears that the state has no objection to the presentation of those witnesses. We have pared down the number of witnesses that will be called. And currently, there will just be 3 witnesses who will be called, 3 expert witnesses. The other witnesses we will be handling by way of a stipulation.
Thank you, Mr. Burt. To the state, any input?
That is accurate, Judge. We are working with defense counsel with respect to some stipulations. We have decided not to object to the presentation of these defense experts. With that said, during the hearing, there may be objections that are raised if the questioning or answers seeking to be addressed goes outside the scope of the preliminary hearing or borders on a 702 hearing. So we want to preserve those objections.
All right. Thank you, Mr. Gernander. Ms. Nestor, anything further? Or Mr. Burt? And again, I appreciate all parties bringing these issues up now just to remove any misunderstandings.
Nothing further for me, Your Honor.
The defense has nothing else, Your Honor. Thank you.
All right. Lastly, the court wishes to inform the parties that as it relates to exhibits being presented in regards to whether it's published or not in open court, or if copies of the exhibits are given to the public or news media, I will take that up on a issue by issue basis. So per exhibit, all parties will be entitled to object, not object, stipulate. So we have a clear record and the court doesn't make a blanket ruling as each individual exhibit is its own exhibit. And the court wants to apply the appropriate analysis to each exhibit presented in court. As the court does not know and cannot anticipate what exhibits will be presented, even though there has been indication what will be presented, it doesn't become relevant until it's actually moved into evidence. And so that's why the court is not issuing a blanket ruling, wants to see where it's coming in, all the factors that govern whether an exhibit should or should not be admitted and should or should not be published to the court, to the parties, or to the public. And so I just wanted to give that clarification because perhaps in the back of your mind, you were wondering. All right, counsel, I also wish to remind you the purpose of the preliminary hearing and the standard, and I offer that simply as a reminder as you're presenting your evidence, that is the standard that the court is holding to, and just wanted to provide that for guidance to all parties. Unless there is anything else, we will reconvene on July 6th, 2026 at 9 a.m. for the preliminary hearing in this matter. Court is adjourned.
Thank you.
So 11 a.m. Eastern, July 6th for the prelim, which I'm assuming that he's going to rule the cameras on out.
Holy shit, they left that so quick. Jeez, like,
I closed it.
Wow. It's like,
Yep.
yeah.
Done.
Wow.
Pretty much. We're done. You're done. Get out. Get out. As the little says, get out. Get out.
Out. I mean, I mean, if you want my honest opinion, and I don't care if people agree or disagree, this court case is going to be a FUBA.
Yeah.
Oh yeah.
Yeah. 9 months in, and he hasn't even pled yet.
Yeah, they're gonna drag it out.
It makes me it's
The first time I'm gonna have to, for July 6th, the first time I'm gonna be learning anything about evidence they got is at this prelim. But I feel like the defense is gonna be mad because they're gonna probably be objecting to everything.
you did it. You did it. You did it.
No more continuances for the preliminary. Woo! I was scared there for a second.
Thank goodness. However, I have about 15 minutes. I will be over with Nick Starro for a little bit for his Slightly Buzzed show. I have us redirecting over there. Even if you can't stick around, go give him a like. Follow him if you don't. Go give Santa Laws a follow. And I will see you guys in a little bit. We do have a stream tomorrow, probably around the same time, talking about
Do you know sometimes people talk shit, don't they? Sorry.
all the
Like
documents that we were going to talk about today. But we had this hearing, so the documents, the weekly Hales update that we would do today, we were going to do tomorrow because there were some new docs and there are some interesting name drops in there and some reasoning and some mental health stuff. We just need to get into the what the is this?
It's called a game of wits. See who gives up first.
It's a yeah. But I will see you guys over on Nick Starro's Slightly Buzzed. We are talking, what I believe we are talking about is Laura Owens.
Oh God, not her again.
If you aren't familiar with Laura Owens, that case is just as, if not ridiculous, more ridiculous than the Hales. She claims she got pregnant after oral sex.
See, boys and girls, always make sure you gurgle afterwards.
She did not go to health class.
Sorry.
I forgot about that lady. Oh, okay.
I did not see what you're talking about. I don't know what you're talking about. I don't know. So I can't put in a comment on anything that I have no idea. No. So even Charlie Kirk's own YouTube channel was Tyler Robinson case rocked by contempt ruling. Not really. Not really.
Yeah.
Like, not really. So they're going to add more questions to voir dire.
Yeah, that's not right.
That was not.
I'm like, you know how much money the states got? Who cared about they got to pay fine?
They have to pay attorney fees. Shocker.
I mean, how can a cop, when she made that complaint that, with all this throat shit, right? Debbie Does Dallas or something like that. But how the hell did the police or the prosecution, they must have looked at this and gone, free money. I mean, like the moment you mentioned her name, I was like, oh, yeah, throat. Mm-hmm.
Yep, tonsil twins. Anyway, I will see you guys in a little bit because I have to, I need to stand up. Move around a bit. Do your squats. No butt dials. No. Yep.
Dropping your phone.
I don't know what she did. I don't want to know. She got pregnant by The Bachelor.
I mean, that day, did she get a psychological evaluation? Was there anything said about that in that case?
No, but she claims to be autistic, which to me is just like insulting people who are actually autistic.
True.
But I have to get going. We do this Irish goodbye or Southern goodbye every time where we literally say goodbye and then keep talking.
Call me Irish one more fucking time. That's war. We're going world of warships, world of tanks, and we're going to fucking hash it out until I am apology. All right.
So I have us redirecting over to Nick Starro. However, if it does not work, that is the link. That should start in about 15 minutes. I'm going to be a little bit late because, that's
lady stuff. Yep.
But we will be there.
Are we doing final thoughts or what's happening?
We're just gonna yeet.
Oh, okay, yeah, okay. Well, Flash fan, would you like to yeet us out of here this evening?
All right. And
hold on. 3.
Wait.
2.
I want to hear a proper yeet from you, sir. I don't want none of this like. I want to. I want a proper yeet from you, right?
Oh my goodness. You're going to embarrass the boy.
Come on, brother. Let's do it.
He's my little brother. You're going to embarrass him. He's good.
Oh, you still doing the countdown noise?